Ladies and gentlemen, I wish to welcome you to the What Lies in Your Debt conference call. Information pertaining to the FDCPA, the FCRA, the TCPA. For those who are not familiar with the acronyms, it's Fair Debt Collection Practices Act, the Fair Credit Reporting Act, and what is that?
Telephone Communication Practices Act, or Protection Act, however you want.
Protection Act, right. They will be giving you information on how you can effectively use those consumer advocate tools to effectively stop debt collectors dead in their tracks.
And a bunch of other stuff.
Maybe even wish they were, because it's been out of the, I think, the effective use of the FDCPA and FCRA that two of the nation's largest debt collectors, that would be Wolpoff and Abramson and Mann Bracken, have been put out of business.
Yeah, and I can't overemphasize, John and I were talking about that at the office, this is Jesse speaking, that the strength of the FDCPA, and for the members that are actually on this call tonight, tomorrow I'm going to be posting up a call. I had a first conversation with a debt collection attorney, and I'm recording these calls now for our members. Of course, Gary's editing them out, so there's no last names. I'm recording so the members can see how easy it is to deal with these people. And one of the simple things that I like to do, and I know Richard Cornforth recommends doing this too, because in Oklahoma it's pretty complicated for the debt collectors, but here in Florida, I go to the Financial Office of Regulations, Business Regulations, and I look up and see if the credit agency is registered to do business here with them, not as a foreign corporation, but with them, to just be able to collect debts here, and sure as hell they're not. And the Florida statute, for instance, and most places that have these kind of offices regulate these debt collection. I'm sorry, I'm missing words here. Our regulatory authorities that regulate the debt collection companies have these penalties, and ours just happens to be a criminal misdemeanor. So it's pretty strong when you're talking to the attorney and you let them know, hey, listen, your client is, as soon as I step into the courtroom, because I've already filed the first case, they ignored me until I filed the first one. She called, and then she called me immediately back and says, well, I see you filed the second one, and we'll go into that later in the call. But I said, yeah, and I said, and don't forget, when I step into the courtroom, I'm going to make the judge aware that this is going under criminal proceedings as we go on with this case. So it's going to be interesting. And I said, I'm sure you don't want your client to have another 9 cases filed in small claims and 10 in the federal one. She goes, absolutely not. And so she's a very nice gal, but you'll hear the call. Very simple call. It's more like a Sunday morning brunch conversation, really. A lot of people have that hesitation of filing these suits because they're going to have to deal with these attorneys. And they don't understand that they're people just like you and I. And nothing changes. It's simple to handle. They're generally very, very pleasant. As a matter of fact, one of the forum questions today was, hey, these attorneys, I sent the intent to sue letter. They're calling me, always belittling me, acting like they did nothing wrong. As a matter of fact, on the call, you'll hear me say that directly to the attorney. I know you're here for your client's best interest, and I know you won't admit to anything. And I respect that, and I'll honor that, and that's just the way it goes. So just keep on talking. Let them think they did nothing, because if not, she's not doing her job. But the question was asked that, when I talk to these attorneys, they always want me to explain to them what they've done wrong. And John's, Larry's, and myself's position is I'm not here to educate you on anything. If you don't know what you did wrong, then that's your business. You're going to have to explain that to the judge, not me. I can tell the judge what you did wrong. You've got to be able to tell the judge that you didn't do that wrong and why. So it's not our job to be educators to these debt collector attorneys and companies and judges and everybody else that's out there. The law is the law, and with our site, the way we've developed it, it's easy use, and for all the members. We get thumbs up on a consistent basis, and we love it. We appreciate it from everybody. And we got some new things that I'm popping, Jeff, that I'll share with you tomorrow.
Oh, okay.
We're going to send out to the members. I think everybody will really enjoy. I've ran it through a couple of good friends of mine that have been doing this for years and years and years. Not doing what we're doing, but doing their own thing with the Patriot movement and da-da-da-da. And they said, man, everybody should jump on that. And if I take their opinion as gold, buddy. So before I do anything, I don't want to be ever called a patriot for dollar or any of that stuff. Our goal, sincerely, is to help the homeowner and help people fight back. And one of the purposes of the design of the website was the simplicity factor, 6th grade level. Don't want to, I don't want to hurt anybody's feelings or insult your intelligence, but, if you get it any more complicated than that, it starts to get really incomprehensible, and there's a lot of information. That's the problem. So when I hear comments like, "Thing is easy," the tutorials are great, the webinars, people are listening to our webinars 2, 3, 4 times each webinar, going over some of the materials. We try to keep them short. Everything we do is very, what's the word I'm looking for?
Elementary.
Yeah, compact and concise. That's a good one. To make it understandable, to make sure we limit the amount of information that comes out to just useful, easy to comprehend information versus a bunch of nonsense to dress it up and make it sound like it's something that is more than it is. And something that Larry and I have discovered, and John is now finally looking at it like a little kid. He's almost like a kid in a candy store, and he can vouch for that himself, is how strong that FDCPA is against foreclosure.
Well,
it's probably the most underutilized tool there is across this country, and attorneys know it. Everybody knows it. The problem that the attorneys have, and I'll say this, and if there's any attorneys on the line, I know we have some. I think we have 2 attorneys that are members, is that attorneys don't want to sue other attorneys, Jeff. And part of the lawsuit comes in immediately, whether you're in judicial or non-judicial, is if you have an attorney that's a substitute trustee or an attorney that's, handling the case on behalf of a bank or a servicer or a credit card for that matter, it's irrelevant. The first person you're going to name on there, besides obviously the alleged is that attorney. End of story. He's a debt collector. That's been firmly decided in the Supreme Court. That, and I don't care, like in Florida, for instance, the exemption comes in as anybody, and now, of course, Florida being as crooked as it is, the exemption applies to any member of the bar. Screw you. The Supreme Court said that if you regularly practice in collecting debts for other parties, you're a debt collector, and I don't give a damn what Florida says. So it's very, very strong, but no attorney that I know yet will turn around and sue another attorney for that. And the Supreme Court's also decided the damages. So the way we set up our system, if it works post, which I like to use, of course, I always like to plan ahead. Pre, post, and during. So pre, post, and during. So it doesn't really matter. If you get served, you immediately sue them, whether it be judicial, non-judicial, notice of sale, etc. Sue them immediately. Don't wait. Don't do anything. Get out there and sue that trustee, sue the substitute trustee, sue MERS, sue whoever the hell's name you can find on any assignments in public record. You put it all together and you sue them. And it's not a countersuit, it's a suit. And then John's technique, obviously, the information is also this. We come in for temporary injunctions, the TROs. You come in and you do our motions on our side. There's different tactics, and depending on where you're at. Unfortunately, for guys like Larry, John, and myself, a lot of the clientele or members that we have in our family are people who basically come in at the last minute. Oh, my house is going to be sold in a week. Will your system stop that? Well, yes and no, but it's mostly up to you. I'm not going to take your case for you. And unfortunately, that is a lot of the people. I prefer, obviously, somebody who's been served or just got their notice or is planning ahead to do a strategic walkout or, has some kind of time. Because other than the bankruptcy at the last minute, there's not much can help you. Now, you can file the bankruptcy, kill the sale, and immediately sue in Fed court and be done with it. So there's a lot of ways around it, and our system's here to teach that, and obviously the support's there. We give a lot of support, and if there's any members that are here, they know. We got forum, we do our webinars every week, we do our calls on Tuesday nights, and I'm just going to kick off another project here. We're not going to discuss it, but very exciting, inner circle type of deal. So that's going to be kind of fun. So there's a lot of support there on our foreclosure side, and there's money back. The system's designed to pay you back immediately. And I always have a saying, we have a 60-day money-back guarantee, no questions asked, because we run everything through ClickBanks. They're the ones who buy our system and resell it. They're the biggest retailers out there, and through the merchant processing system on the Internet. There's no bigger company out there. So we don't have a choice in the matter. If you say, I want my money back, they just give you your money back. We don't have a choice. But the biggest thing that I tell people is if you don't have your $1,000 in the first 60 to 90 days, from any little lawsuit, from FCRA, FDCPA phone calls to TCPA, it's on you because you should pay for your membership for the whole year plus $300-400 ahead of the game within the first 60 days. We've got a member that's settling up on a $6,000 claim without ever filing a suit, just a notice of intent to sue. They realize they were wronged, and they don't want to litigate. It's not worth their time and effort. So and that's been 45 days. So it's up to the individual to put it into motion, and that's really about it, Jeff. I'm going to keep my part short. I want to encourage everybody to ask questions tonight. Get going. I want to make sure we wrap this call up top of the hour or shortly thereafter.
Okay.
And go from there. So John can come in and introduce himself and how his part of his system works, and combined, or what part of the system is his and how it works in combination with what Larry and I have all put together.
So, John, you want to step out and tell us a little bit about your system?
Yeah, sure. Just a couple of things. It's like a story about a California case, but real quick. The whole idea is that you can go out there and sue people and so forth, and maybe someone wants to get crazy and try and sue you, or maybe someone wants to go forward with a collection action or whatever. Everyone has risk, and so part of the program that you'll get into is how to prevent anyone, I don't care who it is, anyone from garnishing wages or levying your bank account. And I don't care if you have any debt at all. I mean, tomorrow your neighbor could sue you for $1 million just because he wants to mess with you. And so then what do? You got to pay an attorney to defend that, and you're going to win. Let's say it's a frivolous case, but what's the cost of defending that frivolous case, right? Even if you get an award for attorney fees, you still got to come out of pocket with that money. But the strategies you'll see in this membership would allow you to prevent or create a situation where you wouldn't even need to go to the attorney. So a lot of people think, getting sued is a big risk. That's not the risk. The first risk is needing to defend against a lawsuit. And so that's what part of this program is all about. But what's a fun case I just got a hold of today, it was a transcript from one of the clients using the forms for the non-judicial foreclosure. And of all states, California. California is the toughest state, I think. And they do non-judicial foreclosures. They just send you a notice of default, notice of sale. And he went and, this is about 2 years ago, he started this thing, and he filed a petition for injunctive relief. And it got to a point now where they've had to stop that sale. He never even filed a bankruptcy. He's going to trial this year. That's incredible. This guy is like a tiger. And all he did was use a simple form, and some of that information is right there in the free part that you sign up when you sign up, on the list. You'll see part of what this gentleman used in California. Now, in the full membership, there's more parts to it, but that's the core you'll find in the free part of it. But this guy actually forced him into a trial, and if you read the transcript, it is so funny. They went to a hearing on, I think it was on Monday, yesterday, and or no, it's last week because they had the transcript back. This attorney was stuttering and wasn't even prepared. These attorneys are so used to coming into court and just saying garbage, and the judge takes up the slack for him. Well, this judge didn't do that. The judge actually sat there in silence waiting for the attorney to answer questions. The attorney was stuttering, and then he set it for trial. And then now they're going through more discovery and depositions and everything, and it just gets really fun. They're just totally unprepared. So that's all I wanted to share with y'all. I mean, I'd really like to answer some questions. I'm sure you guys have some interesting situations going on.
Okay, great. I know we got one new caller that called in that has a foreclosure situation, and I think it's pressing. Maybe one or two others that have a question post foreclosure. But if you have a question, press *6, and what that will do is that'll raise your hand on my console here so that I can see that you have a question, and I will recognize you in order in which you appear. Now, the one person we're going to be starting off with is coming in as anonymous, so I don't know who you are.
This is Ken, California.
Ken in California.
Yeah.
You had a question.
I'm in a post-foreclosure situation.
Okay. How long ago?
I received the notice on the 15th of March. The sale took place on the 15th of March. My lender was Bank of America, and Bank of America sold it to Freddie Mac.
Okay, would that be March this year?
Yes, sir.
Yeah, well, we kind of need to know that.
I'm sorry.
Okay, not at all.
And
Your question is?
My question is there anything I can do to save my property at this point?
Well, without knowing all the details, they went ahead with the sale, obviously. They conducted the sale. Who conducted the sale? Bank of America or Fannie? See, Fannie doesn't want to get involved. There's a big issue with all that stuff. But who conducted the sale?
I believe Quality Loans.
Quality Loans conducted the sale?
As far as I know, I don't know anything beyond that. All I know is I got a notice, very short, brief notice that said, and this was after I was told, I went to a sale just a week prior to the sale, and they told me that it wasn't going to be sold on that date, and it was going to be postponed for 30 days, and they sold it 1 week later without any further notice. And this is in California.
Yeah,
I would slime balls here.
Yeah, absolutely they are. Without knowing all the particulars, the original lender on the note,
Bank of America, was a refi.
Okay, that's what I'm saying. It was refied. Whoever the original lender is on the latest mortgage, because people for some reason, let's make sure I'm glad you said that, Ken.
Yeah, and
whenever you hear me say original lender, is who you have the current mortgage with now.
Yes, Bank of America.
Okay, so they were there, Bank of America. Yes. Was it a MERS mortgage?
Yes, I believe so. Well, okay, it was a Freddie Mac mortgage, so I understand.
No. Was MERS the nominee within the mortgage?
I believe so.
Okay.
Okay, I'm going to stop you here. Beliefs don't matter. You got to know.
What's that?
Belief doesn't matter. You have got to know.
These things to know, Ken, but I'm just building a little scenario for him so he understands, okay. So does everybody else that's listening.
Okay, I understand.
Yeah, if you have, for instance, a MERS mortgage, okay, in the Helping Families Save Their Homes, I discussed this a few weeks ago. It is law as of May of 2009 that any time that there is a transfer in that mortgage, they have to give you notice as soon as possible or within 30 days. Well, if not, they're in violation, okay?
Are you saying after the sale or before the sale?
No, sir. Say I sold Jeff your loan.
Yes.
I have to tell you immediately. That's the law. Not only do I have to tell you, I have to tell you that I sold it, who I sold it to, where the transfer took place, and where it's memorialized in public records. See? So you got them under the FDCPA. I'd sue everybody under the FDCPA. And then once you file that, you go to the federal court and you say, listen, I want a temporary restraining order or injunction until this is brought up, because I don't believe that the person who foreclosed on my house had the right to foreclose.
Yeah, I understand. That's my belief.
Okay. So once again, it's all on our site. The pre, the during, and the post. There's always a resolution. It's just people don't, they panic or they go nuts. So, there's no sense in panicking. It really isn't. Things are going to happen. It's just how you handle it.
I understand that. I'm not panicking, but I do above it.
Oh, you don't sound like you are, which is a fantastic thing. So I'm hoping that it makes a little sense to you when I tell you that. The federal court is, like I say, a ballroom dance compared to it's a discotheque down below.
Yeah, I understand.
Really. So if you file that way against those guys and you run in there and you say, listen, I need a temporary restraining order. They sold my house. I'm going to be evicted, and I don't think they have the right to sell it. And I'm suing them. You talk to the judge in the right way, and they might, even California, they might be on your side. They might be compelled to listen to you. Because if you really sit back and you think and you reflect back, and this is for everybody here, all the great foreclosure decisions that have come out over the last year, 2 years, 6 months, a week, all come from the federal courts. There's never a good decision that comes from a circuit court.
Right.
Very rarely from a circuit appellate court.
And one of the facts here, the fact that they didn't notice you as to the sale date without proper notice, that alone is probably enough to get you an injunction. That's right. So,
what I had in mind, but I wasn't certain. That reason for my question.
Yeah. So
and they didn't notify me that
you do have remedy. There's no doubt about it. It's just a matter of how you want to exercise that remedy and how aggressive do you want to be. That's really what it boils down to, and that boils down with everybody. I tell everybody, you got to do your due diligence. You got to follow through, and you got to study up. And part of who I would sue, I'm sure there's an attorney involved somewhere in your case. That's the first sucker I'd put on there.
Yeah, the notice I got received was from an attorney's office.
Sure, that notice on the bottom of it said, this is an attempt to collect a debt. Pay attention. I'll guarantee it.
I don't see that.
Well, he's a debt collector.
There was just four short sentences, and then below that it just was relocation assistance or month-to-month lease offer.
Okay.
What the heck is all that about?
That's a violation.
Yeah. Holy
You already got one.
Yeah. So you can go on and on. Once again, for those of you, we don't talk about our website on the phone call for several reasons, but you do have emails. You know who sent you those emails. The links are right there on those emails. The best thing to do is go on the site. There's a ton of freebies to download, ton of material to read, and then, of course, to get into the very guts of it, you just become a member, and it's $99.
Yeah, I wish to do that, so I'll follow this.
And if you'd like, we did make some changes. A lot of the guys say, listen, I don't want to pay the monthly deal. It's $680 for the year. So I will take a certified check, but you got the email. If that's the route you want to go, make sure you just get back to whoever you got that, and they'll send it over to us, and we'll give you the instructions on how to get us the certified funds. You pay the one whack for $680 for the year, and you're done. You don't have to worry about the monthly and the credit cards and da-da-da-da-da. So,
sounds good.
There's other options. We're trying to help folks to get in there. But really the reality is, guys, we, and I mean John, Larry, and myself, are not ever going to tell you, do this, do that, do the other. We do not give legal advice. We're not attorneys. If you want legal advice, obviously go seek an attorney. But also with that legal advice and seeking that attorney come handicaps, and that's just the way it is. And there's benefits. When you sell something, it's the features and the benefits. Nobody ever tells you the negatives.
Right.
Right? And there's always features and benefits to having an attorney. But at the end of the day, what's the negatives? And, I would rather make a few mistakes. I would rather go through there and make a fool of myself every now and then if it happens. It's just the way it is. But at the end of the day, as I told one attorney, listen, those rules don't apply to me. So, and that's the wonderful thing.
Right.
They have to adhere to all those rules. We don't. So we can make mistakes. We can do our things, and we're okay with it.
Right.
And 99.9% of the time, and John can tell you, we make attorneys look like fools. They're not prepared to litigate. They're literally high-paid secretaries, paper shufflers, paper hangers, whatever you want to call them. They really don't do much. I hate to say it, but that's just the way it is. So when you get one on the phone, the members that are on this call is going to hear this call tomorrow. You will hear the crackling in these people's voices, okay? And I'm playing stupid. But as I'm playing stupid, what I'm saying has a lot of punch to it. And that's when they go, oh, God, this guy's just going to mess my whole world up. What did you say, John, today after I got off that call? You said something about, oh, this guy's just smart enough to screw the whole thing up for us. Something like that. But I still didn't come out like a smart aleck and I'm quoting everything. And no, you're just, you're in violation of.
You guys will hear the recording, but what the attorney has to be thinking on the other end, and Jesse's over there just be real calm and, he's saying, look, I don't do this for a living, so, I'm just going to do this thing and do it this way, and, let me know what you think. And so that attorney on the other end's got to be thinking, this is a damn shipwreck. This is a shipwreck for my client. And
that's what
I'm
you
talking
said,
to a consumer that's driving the ship, and he doesn't even know what he's wrecking. And I have to go get back with my client fast because this is going to be disaster.
I told her, this is how I approach these guys. I says, well, there's 12 documented phone calls to my cell phone. So for simplicity's sake, because I don't do this for a living, I'm just going to go ahead and file one case at a time for each phone call. And I said, let me be clear for you so you understand my game plan. I'm going to file one claim against your client in the small claims for the state and the TCPA, and then one claim in the federal court for the FCRA and FDCPA. So that means I'm going to have to file 22 cases because if I don't do this for a living, that's the only way I can keep track of things is individually. And I know that's when John looked at me nodding his head like, oh, God, this lady's got to be thinking, no shit.
You have to
the shipwreck guy, he doesn't know that he's doing everything correctly.
Yeah.
You know,
and
but
you have to understand that the first consultation the attorney has with the client is about fees and costs that they expect to incur. And then when she has that conversation with Jesse on the phone, that's blown out of the water. Now she's going to go back to the client and say, you know what, I'm sorry, it's not going to be $1,500. It's going to be about $12,000 this quarter. Yeah.
Yeah, been there.
Yeah. So, those are the kind of angles that we encourage everybody to learn to use on their instead of educating people. Just act like you're dumb as a brick, and I got to do it this way because it makes it really easy for me. I can build a spreadsheet. I mean, I talk to these attorneys just like that, and they're like, "What in the hell?" It's like John said. They got to be thinking, "My God, this guy's like he doesn't have no idea what he's just created here for me and my client. We got to put a stop to this." But you come in as a dumb country bumpkin, and that's what you want. That's really what you want.
Yeah, that's me anyway.
Yep. Let's move on to the next question. Ken, God bless you. Just jump on the site, man. Get in there. There's plenty of free stuff to download and webinars, and we encourage everybody to become a member. I mean, like I said, we want everybody to make money, not be hurt, and not we don't want to take anybody's money that's not earned.
Thank you, and God bless you.
Yeah, God bless you, brother. You have a good night.
Thank you.
Okay. Next up, we have D in California.
Hey, D.
Thank you for taking my call. Yes, I have a situation where I have been in a so-called situation for trying to get a loan modification for the past 2.5 years, and it's a big joke. And
it is. I'm sorry, man. I couldn't help but laugh. I'm sorry. That's just a joke. The word loan modification. Oh God.
Oh no, I do the same thing too. I laugh all the time because it is a big joke. My question is this: when I first started out, I had a first and a second.
Okay.
The originator of my loan was a small company that has since gone out of business. It was about a month into my loan. It was handed off to Countrywide. Now it's in the hands of Bank of America. Now,
yeah, Countrywide. Okay.
So what ended up happening was the first and the second were together, okay, and Bank of America had both. About a year ago, Bank of America sent me a notice telling me that they had sold it to Real Time, sold the second to Real Time. They still hung on to the first. So now, because it's been so long since they've gotten any payment or anything from me, I'm suspecting, especially being from California, that something may be imminent. And I'm wondering what proactive, because there's no type of action taking place right now, what would you suggest as far as practice so I can be prepared? Because a lot of people I'm hearing are being surprised. All of them, they're hit with this. I'm in a situation, luckily enough, I know that it's imminent, but I need to prepare myself. And what steps do you suggest? Because there's just so much information on the site. There's so much there for us. And it kind of hits me all at one time. It's kind of overwhelming. I've been a member for two.
What you need to do, you need to stop, take a deep breath, okay, and go back to that site, and you know that it's laid out. Step 1, step 2, and you need to do it one step at a time. What you're doing is what the typical person does: jump in and wants to see everything on the site all at once. No. And if you notice in our members area, in the welcome area, I tell everybody, listen, do not go anywhere else on the site unless it pertains to your particular instance right now. Meaning, if I'm in foreclosure, I'm going to stick to the foreclosure non-judicial side of that site. End of story. I'm not going to go check out foreclosure this, credit cards that, MERS this. I'm going to stick here. Step 1, run the checks. Fannie, Freddie, MERS. Go to public records. No assignments, nothing. Qualified written requests. Listen, our game, which I call it a game because that's all this whole thing is, whether it be credit card debt, foreclosure debt, student loans, IRS, couldn't care less. It's all a game, okay? And I'll tell you what, John filed one piece of paper for a friend, with a client who is now a longtime friend, real old lady, and I don't mean that disrespectfully. She's in her 70s. Very nice gal. IRS garnished her wages. He filed one piece of paper. Bang. They returned her money. Stop our garnishing. Done. That fast. So it's a game, guys. Okay? It's just a matter of who knows how to play it better. And when you say conditions precedent, I'm talking about conditions precedent. Okay? You're going to send out a qualified written request. People underestimate that. Well, you know, on our member side, the guy, and it's all over the place, but the guy that in Pennsylvania, I think it was, sent out a qualified written request to Wells Fargo. Wells Fargo ignored it. He foreclosed on Wells Fargo's local office. You know, come on, guys. The FDCPA, the SCCPA, all those things are very simple to use. Our game is simple to play. It's not hard. It's everybody else out there that tries to make this thing difficult, and that's where we finally said no more of this nonsense. So you need to take a deep breath, go back to the site, get onto the member side, and get on to step one. Run your MERS check. Run your FANI. Run your Guinea. Go to public records. Send out your qualified written request. These are all step 1, 2, 3, 4, 5. It's simple. Step 1 through 5 you can finish in about 2.5 hours. Tutorials, the reading materials, your check on public records. It's all right there on the computer. You don't need to leave the seat of your the chair of your office. You don't need to go anywhere. It's all right there. So those are the pre-foreclosure things you're doing prior to foreclosure. Meaning, okay, I sold the note to Jeff on the mortgage. Like you said, it was sold to, who was it? What was it again? Who was it?
Real Time out of Texas.
Real Time. I'd go do homework on Real Time. Who's Real Time? Who owns Real Time? I could almost somehow, and I don't know, maybe I'm completely wrong here, but I remember something about Real Time over a year, 2 years ago. Bank of America owned them. Some kind of subsidiary of Bank of America. If I'm not mistaken. I could be completely 110% wrong, but double check that. Who's Real Time? Where are they incorporated? Are they licensed to do business in California? You know, these are the things that we always recommend people to do that are simple things you can do right online. You don't need to go anywhere. You don't need to have any specialized knowledge. You don't have to have anything. Simplicity, man. So I'm going to say it again. Go back to the site, read and listen to the tutorials, how to check through MERS, how to check through FANI, how to check through Guinea. The links are there. You input your information. You're going to get your answer. Ken said his was sold to FANI. Well, once again, all these things are violations of TILA. There's no memorialization to you. If there's no notice of sale, check Section 20 of your mortgages. It's right there. That is the least, John, what's the word I'm looking for? Utilized, I guess? Attack that you can use. A specific breach of contract. Mm-hmm. Even though it's not a contract. We all know, I mean, most people on here on this call know that these mortgages are not contracts. You know, they're covenants, they're promises, or nothing. So, but if it says Section 20 that notice will be given and they don't do it, they violated their little covenant, their agreement with you, right? So pre. Once you find out that they don't own your mortgage, that you don't know who owns your mortgage, that they never recorded it, then you start sending the qualified written request, obviously to the original lender. That is, once again, original meaning as the current mortgage holder, okay, that you have on there. Once you have that, then you go ahead and you do your thing, right? Qualified written request to that person, et cetera, et cetera, et cetera. Why? Because they're not going to answer. So you're going to move on, So long story short, obviously we can't go into the whole entire thing, but that is the premise of the pre. You're going to put them in a position to get their butts in court or to get your property out free and clear, meaning you're going to go in, you're going to do a small suit for quiet title against these people. Yeah, I don't see that, Barry, here. Yeah, they're just a small company. If it's Real-Time Mortgage Company, it's just looking at $500,000 to $1 million, but it doesn't say, Barry, who's behind it. And I could have swore there was something I was dig up. But anyway, thank you. There is no better witnesses in the county clerk and the sheriff's department. Hey, I sent the original lender. Here it is, right on my mortgage. ABC Lending, qualified written request. They failed to answer. I sent them a second notice saying, listen, you failed to answer. I need this information. I've checked public records, sir. This is all that's on public records. I can't get a hold of anybody. I don't know what's going on. I think they went out of business. See, the sheriff tried to serve him. Here's the return of service. Here's proof that they tried. I went to the county. The clerk said there's nothing on the record. Here it is. This is all it's in public record, sir. Can you please quiet my title? How's he going to argue? You're before the court with no controversy and witnesses that are part of their group, the clerk of the court or the clerk of the records, and then a police officer or a sheriff or a deputy, whoever it is that tried to serve it. How are they going to argue with you? You get it?
Yes. Thank you very much.
See where I'm heading with this? But if you don't do what I'm telling you to do, one step at a time. Let me tell you something, man. When I was 19 years old, 21 years old, I started driving for UPS. And I'll never forget. I was a utility driver. I walked out to that dock. I looked at my truck. I had a P1000, which was one of the biggest trucks of the day. And I thought, holy crap, there's 1 million packages in this thing and another 1 million hanging outside it. How in God's green earth am I going to get this done? And I remember my union steward walked up to me and said, Jesse, you can only do one stop at a time, one box at a time. Don't worry about the other 999. Just do one at a time, and you'll get them all done. So don't be overwhelmed. I took his advice, man, and I was stayed a utility driver for all the 10 years I drove at UPS because I loved it. I wanted to do the different routes every day. I wanted the adventure. I wanted the new stops, the new people, the new places. But I never let panic get to me, and I never got overwhelmed. I didn't care what the truck looked like, what the deliveries looked like, what my day was going to look like. I can only do one box at a time, one stop at a time. I can't do anymore. I'm telling you, man, you follow that theory, and it's worked. It's worked for me forever. So that was a very good lesson at a very young age.
Thank you very much.
All right, buddy. God bless you, man.
Make sure. Yeah. All right, then. Thank you, Dee. And next up is going to be Bobby.
Hi there.
Bobby?
Do the calls have to come to the cell phone, or is the home phone also illegal for them to call?
It depends. The TCPA is very, very clear. Okay? If you have no prior relationship with these people, meaning these debt collectors, okay? Okay, and I'm going to emphasize something, Larry, that Larry always emphasizes. If you call my house and you're a debt collector, I don't know who you are. I'm assuming this is where you're coming from, correct?
Yes, I have a debt collector that actually it's an attorney that
better. Okay.
I've sent a dispute of the debt, and I've also sent them a note saying that their response was not satisfactory, and re-asked for a proof of debt, and they just sent me another letter saying that they weren't going to. Wait, that was another one. Anyway, they just called me today, and I didn't take the call, but they called me at my home phone. And I'm curious.
Just remember that any time that you send out a notice of dispute, okay, because I think I know what you're saying, proof of debt or proof of claim or proof of whatever, some other, I don't know what you're doing. I send out a very simple notice of dispute for verification and validation.
Yeah.
Very simple. Nothing complicated. Ours is 2 or 3 paragraphs. John added one of his in there. I don't know, it's probably half a page long, whatever. Anytime you sent that out, in between the time that you send that out and they respond or fail to respond, and they try to call you or make any attempt to collect the debt, it's a violation of the FDCPA. It's also a violation of your state act. I don't know where you're at. Are you California also?
Tennessee.
Oh, Tennessee. I'm not familiar with Tennessee, so you'd have to look up Tennessee. It's very simple to find. But my point is that you have this little gap there, whether it's 10 days, 30 days, 100 days. If they move, they do anything. And I'll show you how strong this is. I'm just going to give you an example. Foreclosure case, we did a motion to dismiss. Big $2 million house down in West Palm Beach. Year and a half goes by. They finally call up the motion to dismiss. My buddy walks in and says, hey, Your Honor, before this gets started, I want to know what we're doing here today. And she looked at him bewildered. And he said, listen, look in your record. There's the file. I filed a notice of dispute over a year ago or a year and a half ago. Today, by definition, this hearing is another attempt to collect a debt, and they're a violation. They owe me another $1,000. Do you not agree, Your Honor? And if you do not stop the proceedings today, you, ma'am, are committing a crime against me by allowing them to violate federal law. She killed the hearing and gave them 20 days under court order to respond, verify and validate both. They never have. It's been another year. They never have.
Well,
you think they're going to move? They're not going to do anything. It's sitting there quietly. That's how strong that is if you know how to present it. And that was the whole argument. See how easy it was? It wasn't hard. So what I would do immediately for these guys is sue them immediately under the FDCPA, FCCPA. Remember, guys, no such thing as me selling a credit card debt. No such thing as me selling some consumer debt of any kind. I don't care what it is. Can't do it. It's impossible because the debt buyer, first of all, a credit card transaction, by definition, every time you swipe the card, you recontract. Okay? Does everybody understand that? Do you understand that yourself?
I think so, yeah.
Okay? Yeah. I go to the store, I swipe my card, I sign, I just recontracted. So the member agreement changes every damn month, every other week, every third day, because we all get them in the mail. Oh, this changed, that changed. You agreed to this. If you don't respond to it's a constant battle. But by definition, every time I spend a nickel on that credit card and I sign, I've just recontracted, right? So that's the first hurdle they have to come around. Second hurdle is if I sold you the debt, personally sold it to you, right? Now, I can't give you all my books and records. I'm only going to give you evidence of a debt, right?
Right.
Which says, here's some statements, here's some copies and maybe some checks you paid us, but that's it. Who do you have that you can bring to court that has firsthand knowledge of our transaction and our business dealings? Nobody.
Mm-hmm. Right.
You get it?
Yeah.
All right. So that's how you sue them because, once again, what I started to say is what Larry and I promote is sue first, ask questions later. You still have to prove up your case. See, now you're the plaintiff. You're in the driver's seat. You're in charge.
So do you recommend that before I sue him, that I send a letter to him stating my intent to sue and for what kind of amount, or?
No amounts, no nothing. I always say send an intent to sue letter. Why do I do that? Okay, now I can't tell you what to do. I'm just saying and what's worked for us in the past is, sir, Jeff, I'm going to sue you, and I'm going to sue you because you violated X, Y, and Z. Do you want to settle now? How do you want to handle this, pal? You got 10 days to make up your mind. I'm not going to tell you you owe me this, you owe me that, you owe me the other. I can sue you. I'm not going to tell you any of that stuff.
Mm-hmm.
I'm just going to say you violated the FDCPA, FCCPA, FCRA. I'll give you 3 examples. Telephone communication, you want to throw it in there, whatever. And I'm going to sue you. And that's all there is to it. How do you want to handle this? I'm going to give you 10 days. Why do I do that? Because when I step into a courtroom, I can say, here, Your Honor, look, I've been trying to deal with this clown for over a year. He knew damn good and well he was in violation of this. He didn't deny the allegations, but he's sitting here wasting judicial resources, my time and your time. You got it? I want some money. And John just found, John always comes across crazy stuff, where I'm getting, where he's getting attorney's fees. And I can read you an email from an attorney that's trying to settle a case with me that specifically says, we'll come to an agreement for attorney's fees to pay you so my client can pay you. Because I sent her what John gave me. And she says, how are you going to get attorney's fees? I didn't answer her. I just cut and pasted it right in the email. And I said, here's your answer. Read it for yourself and educate yourself. Well, her email was a response of, okay, I'll talk to my client. It wasn't, screw you, you're wrong, it doesn't matter what that says. Her answer was, okay, I'll talk to my client to see what reasonable attorney's fees are. See, and it's simple. Once again, attorney fees. Yeah. No, I just want to be simple. Hey, guys, this is black and white. It's not gray. Right? It's very, very simple stuff. And that's why we promote our site to everybody. The simple-minded, the brainiacs. It doesn't matter. What's happened, and what I've seen happen over the last 3 or 4 years is, and some of you have heard, you're probably tired of hearing me say this, is you got some lady wearing this lingerie with this trench coat, fishnets, beautiful hair, her eyes are covered up, but it's all this mystery. We just give you the naked lady. You know what's under there anyway. Why am I going to make you dig through all the layers of crap? You already know it's here. There it is. Go put it to work. Does that make sense?
Yeah, it does make sense. I have the foreclosure that's been happening on my property. I've started a federal case against the bank. I looked at my counter record. I'm sorry.
For what? What's the federal case based on?
It's Jeff is familiar with it. It's the one that.
I know. No need to mention. I know which one you're talking about.
Yeah, it was the one Todd was doing.
It's been getting kicked court left and right, correct? Meritless.
I'm sorry, say that again?
It's meritless. It's been the one been getting kicked out left and right?
No, this one is my amended complaint. The original one, in answer to their response to it, I amended the complaint with Todd's type of case.
Right.
But in the process, I looked at my counter recorder again, and they have since filed an assignment of deed of trust from MERS.
They cannot.
It says, let's see.
I know what it says. I've seen about 10,000 of them.
Yeah, it says that MERS is the holder of a note, which is not true. Is that's the case,
Absolutely.
right?
Sue. You see, now you got to sue MERS. And when I say sue MERS, you sue the person who signed as vice president, assistant secretary, garbage picker for MERS, whoever the hell it is for MERS, sue them personally.
And also on the document, it says prepared by and returned to Joe M. Kirsch, attorney in Memphis,
Correct.
which that's the attorney. Shapiro and Kirsch are the attorneys that were foreclosing on me. But in addition to that, since J.P. Morgan
we got a dance started here, my friends.
Is the assignee, is the one that purchased this loan from MERS.
Let me tell you something. Just listen for a quick second. This will benefit everybody out there. I have a home in Tampa that I've been in foreclosure with going on 4 years. It's been dead during a movement on that file, okay, and there's not going to be. That's one of those houses that will run into the statute of limitations to 5 years. I'll just walk away with it free and clear without having to do anything else.
Mm-hmm.
And the reason I'm so sure of this is the assignment was prepared back then by David Stern. Okay, we all know. Yeah, David Stern went down the hill. Shapiro and Fishman are my favorites here. We've sued the crap out of them. I'm fixing to do another one this week. Prepared by and returned to. Okay? We have a problem here because when somebody's foreclosing on you and MERS is not brought up as a possible, defendant, okay, it's failure to join indispensable parties. They might have an interest in the party or in the I could say party, in the case, right? Think about that for a second. I brought this up 4 years ago, and Stern ran the other way. Like, leave that one the hell alone. Let's go make some money on some other one. Because I said, listen, how can Stern defend the plaintiff and the defendant at the same time? Because he failed to join indispensable parties, which is MERS. MERS should be a defendant. So now Stern has to be front and center in this case because he prepared this assignment. He's playing both sides of the fence, and that's very unethical. Not only that, it's against the judicial rules of administration.
Is that what Kirsch is doing in my case?
It's the same in your case. How can the attorney prepare this? So I would sue the attorney. I'd sue the attorney.
And would it be part of my same federal case? Would I add it to my case?
Oh, no. You want to start another one. Keep them busy, man. Come on, man. Fun.
Should I enter some of
this
have a information?
If you sue her?
I'm sorry?
In another case and then relate it back to this case? You know how they ask you, does this relate to another case? And you say, no. Well, this one you're going to say yes, and you're going to put the case number down. And then you're going to go to the judge and say, I think there's a conflict of interest here. She cannot represent her client here because here she's actually she's a defendant along with MERS and her client.
Also, the fact that MERS is the one that's assigning this to J.P. Morgan, that's J.P. Morgan is the who I have the federal case against. The attorney that's representing J.P. Morgan is representing based, I would assume, on this assignment of deed of trust coming from MERS, which they've been showed to be not really capable of having standing to assign anything.
Correct. I just gave you the whole puzzle, man, 5 minutes ago.
So should I amend my existing case to include this assignment of deed of trust in any way?
No,
and go after
you didn't listen to what I just said a while ago. Sue separately.
Sue separately, sue Kirsch separately. But since I already have this other case open,
sue her separately. Sue JP separately, or not JP, the original, whoever the assignment's coming from. Meaning
MERS, you mean?
Right.
I would sue MERS.
The attorney, MERS, the signer on that assignment from MERS, and the assignee from MERS. Who is assigning it?
The person, Gwendolyn Austin.
No. ABC Mortgage has to assign it through MERS to J.P. Morgan. MERS can't assign anything. MERS, they don't have anything.
Well, it says, whereas Mortgage Electronic Registration Systems, hereafter called Assignor, is holder of a note dated September 1995.
Okay, that's it. Then you sue MERS and the attorney and everybody. And I would do a RICO probably. That'd just be my probably chosen route.
You're going to find out that even on the MERS website, where they have the MERS manual, it says explicitly that they cannot ever take possession of a note. So that's fraud right there. That's perjury.
Yep, and it's right on our site, by the way. We have a whole MERS section that specifically refers to that.
Okay, so
Jesse, we're getting about 6 minutes away from the top of the hour. We got 10 questions pending.
Thank you. I'll do some more research. Thank you.
All right. Appreciate it, man.
Thank you.
Okay, well, next up is Sylvia.
Oh, yes. Thank you so much for taking my question. I just joined a couple of days ago, but I'm getting a little concerned because this is way over my head. I'm one of the old ladies you were talking about a while ago. I'm in my 70s. I have looked at a couple of the webinars. I can't find a place on there where it shows you the recorded calls because I only joined it a couple of days ago, and I have a feeling I just can't do this. Some of the words that you're tossing out just now, talking to some of these gentlemen, I don't even know what they mean. And so I'm thinking it's just too hard for me unless there's somebody there that can help me do
We have no live help.
Pardon me?
We have no live help.
Okay, well, that's kind of what I was thinking. And I can just see, by the way, it seemed like the other callers understood what you were talking about, but I don't. It's totally, you almost have to have a law degree to understand what you're saying, and I don't have that. So.
No, I'll say on this call has one. But the reality is when you go to the site, if you go to the members homepage once you sign in.
Yeah.
Okay.
Yeah,
right.
I did. I went through the Windows, the members homepage, and looked at the fundamentals of foreclosure because my house is in foreclosure. It's due to sell the 26th of this month, according to the public records. No one has told me that through Wells Fargo. However, I did find out that it's due to sell on the 26th of this month. So
okay. I want you to do this. I want you to go. Well, first of all, I want you to wait till tomorrow or the next day. If you just don't think you can handle it and you're going to opt out, at least wait a day or two because I am sending an email and then make up your mind, which is fine. If you can't handle it, some people just aren't cut out and don't feel bad for it.
Oh, I don't feel bad.
You don't understand it, and I really appreciate your honesty.
Well, this is just not my expertise, and I'm thinking, it's way over my head. I can't figure it out. I did look at some of the webinars, and then I think I got to the third one, and I thought, what are they talking about? Now, I checked it out. I have a second on it, and it is a MERS. The first one is not, and I'm in a non-judicial foreclosure state, which is California. So I did find out a few things, but then, like I said, when I got to the third, I think it was the third webinar, I thought, I don't know what they're talking about. Some of these things are, and it would, even though you say, act stupid, well, I wouldn't be acting stupid. I would be
You're not, don't even say that. Come on now, that's bad.
Well, I mean,
I don't think you're going to learn everything that we know. We didn't learn this overnight. At the beginning, we were just like you, trying to figure out pieces and puzzles. And we didn't have any of these tools. We didn't have a user-friendly website. We didn't have phone calls. We didn't have any of it.
I understand all that, but you're talking like everybody else, or including me, should know all these things. And I have no clue. I have no clue what you're talking about. I have an expertise in other things. So I don't feel bad about it at all. I'm just thinking maybe I'm doing the wrong thing here because I don't. At my age, I'm in my 70s. At my age, I don't want to learn something new like this all over again. And
no, then actually, you said you're in California, and the problem that I'm going to see in California, and John, correct me if I'm wrong here, is finding some good attorneys over there that can get it. What area of California are you in?
I live on the Central Coast, right in the middle of the state in Santa Maria.
Okay.
Right.
Let me do my homework. tomorrow, send my webmaster an email, would you? And just say, listen, I was looking for an attorney recommendation in the Central California area, and I'll get on it for you tomorrow. I have a list of about 5,000 foreclosure defense attorneys across this country.
How do I send an email to your webmaster? I don't quite understand.
Go to the website, and it'll say contact us, and just jump there. Yeah, and send it over there, and I'll give you a hand with it. Because you know what? You're right. At 70 years old, if I had to learn, I wouldn't want to either.
Yeah, exactly. I think. Well, I don't think so.
Are you working by yourself?
Yeah, I'm a widow.
You're working by yourself. You don't have any younger people like your children or family or friends. I don't even work alone, and I've been doing this for 20 years. I can't work alone. So that just goes to show you right there. It helps to have a group or a couple of people to work.
Yeah. Oh, that would be nice. I just don't have that option though.
There's the forum. The forum allows you to talk to other members. I think, doesn't it, Jesse?
Yeah.
Well, I looked at the forum, and there's a couple of people that were asking questions, and the responses they got back were, cut and dried, and it was. I mean, I don't expect you to go into detail for just $99. I totally understand what your situation is, and I appreciate what you're doing. I really do. It's just that I think, well, I can't even understand that. So, but and I, just sometimes you don't even know what to ask because you don't.
Right. Right. And that sometimes you just have to go let somebody else handle it for you, and that's just the way it is. It's just the way it is.
Yeah.
But I don't suggest you go let somebody that doesn't know anything or claims to know everything do it. I'd rather you go and make sure you're protected. Get yourself a decent defense attorney out there. And there's some of them out there. I do have some of them that I'll recommend you. So just set the message out there. Get me a message, and I'll make sure I connect you to the right parties over there, at least in that way you can make the decision.
Now, who am I talking to now?
This is Jesse.
Jesse? Okay, Jesse. Thank you, dear. I appreciate that. I just don't know where to start, and I just
don't worry about it. Don't worry about it. Like I said, just get us the message over across, and then I'll hook you up from there.
Okay, thank you very much.
All right, God bless you.
You too, dear.
Thank you. Jim. You're up, Jim.
Yeah. This is Jim on Texas. I had a foreclosure. I was working with another fellow that they wrote a federal lawsuit for me and finally got it to me the day before the foreclosure sale. I filed a federal lawsuit. They went ahead and had the foreclosure sale. That was on August the 3rd of last year. I'm still in my house. The case is still going on. And about a month, we had a mediation back in January, and they didn't come up with any of the paperwork that I asked them for in the mediation. And so they filed a deal for a summary judgment. Well, through my research, I found out that they can't get a summary judgment against me since I'm doing this pro se. That's according to Haynes versus Kerner.
Right. But I'm just looking. Have you done interrogatories, admissions, requests for production, all that stuff for these guys?
No, I filed a suit. I was the plaintiff, and the guy that wrote it for me just kind of won't answer his phone or won't return messages or anything else. So I just out there by myself, hitting, doing research, and that's the reason I joined up with you guys, because it sounded like you was the first one to run on to that seemed to know what you were doing. But I'm writing a deal right now.
Because you're going to be interested in the next couple of days when I'm pumping out for everybody, and it's particularly just for the Fed court procedures, because you don't want to see the Fed court's very, very. I'm going to keep this as short as possible. It's a very formal dance, and what I mean formal is you can't screw around. You can't be wearing a suit and tie and then show up with sneakers. It ain't going to happen. They won't let you into the dance. So you got to make sure that you follow the deadlines. You get your things together, your paperwork submitted, et cetera, et cetera, et cetera. If not, you're going to lose the case. I don't care how good of the case it is, you're going to lose it.
Well, I've got the April 22nd to file this motion against their summary judgment. I've already started a deal, and I'm doing this on myself. I got a deal here headed up plaintiff's motion to squash the defendant's motion for summary judgment, and going on down through here why I'm.
Yeah, you can do all kinds of different motions.
And My question is right now, I'm running, like I say, I've been working on this for a couple of days and looking and writing and typing into the computer on the. It's my understanding from some of the research I've studied that the trustee cannot bid at this foreclosure sale or even actually hold the sale. Am I getting bad information from somewhere? Or?
I'm not. John, are you familiar with that? I've never heard of that.
Wasn't it you who showed me the pooling and servicing agreements? The trustee can't get into a foreclosure?
Oh, that's just a trust. He's in a non-judicial. He's Texas, remember?
Yeah, this is judicial because it was an equity loan.
Okay.
Oh, okay, so it is judicial. So the trustee, meaning you say, how are you saying the trustee? Because if it's like...
Well, what happened is I took this loan out originally with a company called New Century.
Yeah, I know who they are.
They went belly up, I understand, in 2007. Next thing I know, I get a deal from a company called Carrington Mortgage Services.
Correct.
So I go to paying them.
Right.
Well, I got involved with a fellow by the name of Tim Turner, and I went through all that rigmarole and sent them a promissory note, and they didn't send it back, they didn't honor it, and they won't send it back now. But they sending all the other paperwork back, all the other stuff that I sent them. They send me copies of it in this summary judgment deal. But what I have been able to glean, then there was a law firm out of Dallas, Mackey Wolf and Zink or something like that. I've got paperwork in there. They're the ones that started making all the foreclosure noise for Deutsche Bank Trust or something like that. Yeah, Deutsche Bank National Trust Company as trustee for Carrington Mortgage Loan Trust Series 205 NCI Asset Back Pass Through.
Yeah, I get it. Listen, that's what John was saying. Under the pooling and servicing agreement that these guys have as trustee of these certificates, they're not allowed to know anything. They're not allowed to know a damn piece of information about nothing within inside of any one of those certificate holders. That's right in there. A trustee is literally oblivious and has to remain oblivious to it. So he cannot foreclose. He cannot do anything. And that's a fact, because you cannot foreclose. You cannot make allegations. You cannot defend a lawsuit if you don't know anything that's within that trust. You can't, because you're not allowed to know. And it's right within their own servicing agreement.
This law firm sent an attorney, which is the alternate trustee or something was her title, up from Dallas up here to our little old county to hold a sale, and she's the one that held the sale.
Yeah, well, she needs to be sued.
Sheriff never did have a hand in it, and I asked her flat out, and I've got all this on a video recording. I had a friend run my video camera for me, and by us filming her, she was as nervous as a dog passing peach seeds, and but we got it all on film, and I asked her flat out if she had a real estate license or an auctioneer's license where she could hold an auction. And they bought. And now they're claiming that Deutsche Bank is the owner and was at the time of the foreclosure, which was not true.
Well, once again, FDCPA suit.
Okay. What my question is, I guess, because I'm working on this thing, and I heard what you told that other fellow, can I file another lawsuit against the law firm and Deutsche Bank and that trustee that held the sale and all that, separate from the lawsuit I've got going on?
Yes.
Absolutely so.
And how about filing on the lawyers that are now sending me this paperwork that are representing Deutsche Bank?
Don't leave anybody out of the party.
Guys.
The more party, the more fun it is.
Okay.
Yeah.
Well, yeah, man, get the party started with those guys. Don't wait around.
And that's what I was thinking. That's the reason I joined up with you guys, because I've known Jeff.
Don't wait, man. Don't wait around. Get up on them and start now.
But I wasn't sure that I could sue that other attorney on the other side that's representing them now.
Well, did he file anything into the courtroom?
We haven't ever got to the end of the actual courtroom, and they filed this request for summary judgment.
Yeah, he's just trying to get rid of you. You're a pesky pro se.
Well, I'm not easy gotten rid of.
Yeah, that's just what he's thinking. So we got to file the federal lawsuit against him under the FDCPA, and I wouldn't include him. I would include everybody else. That's all.
All in one lawsuit or separate?
No. In the next lawsuit, all in one lawsuit.
Okay. But I can find all that stuff on your site?
Oh, yeah, man. Just like I said, one step at a time. You don't want to get overwhelmed. You want to, and we've made it so damn simple, I can't make it any easier. If I'd made it any easier, there'd be no damn information on there.
Okay.
And I'm telling you. And I know
all
some
right.
people just ain't cut out for it, and I respect that. But look at it as a part-time job. You're coming in there, you're going to have to learn some of these things, and sometimes you might have to, listen to it 3, 4, 5 times before you get it.
Well, it's kind of fun
to learn it.
Learning all this stuff and finding out how you can go after these crooked-ass lawyers.
Exactly. Listen, I'm going to tell you something. Matter of fact, I forgot all about this. My son's friend over at our club Monday, and I even forgot to tell my father-in-law who's sitting right here listening to the call. I walked in, he said, hey, I won my credits. He had I forgot to tell John, too, dang it. He had a credit line with J.P. Morgan Chase. He said, Jesse, I'm going to sue him. He joined our site. He didn't sue him. He got so busy, he actually works for NASA. He's an engineer, very good friend of ours. Well, I come into the club Monday. He says, well, they got rid of it. They eradicated the whole thing. I said, what? And he said, they got rid of my credit line. It was $102,000, $101,000, something like that. And for till violations. And he says, I went ahead and hired an attorney to do the formalities. I didn't have time for it, but I had to educate the attorneys. I'm not kidding you. I'm going to make a testimony. He's going to give me a testimonial. I'm going to video record it Friday so I can put it on the site. You ain't going to believe it. He says, I just hired the attorney to do the paperwork because I never did sue him. The attorney would just call them and they'd get some letters back and forth and stuff, and that was it. But he says, I had to constantly get stuff off your site to send to him.
And he was charging him a couple $100 an hour.
They took the second clear. Cost them all of $1,200 with the attorney. Or no, $1,500 with the attorney.
How do we get our credit report?
Jesse, we
Follow
have
on the site. All you got to do is
in less than half an hour.
Yeah, freecredit.com or it's freecreditreport.com, and you go there, you get one a year. So you download them and you start hunting from there. Once you dispute, of course, then you can. They're going to send you your updated credit reports, and then you dispute it again, and they send you some more updated ones, and you get a dozen of them every year if you want. So
okay,
all right, we got to get to the next question. It's already a little late. What time is it now? All right, buddy. God bless you. Have a good night. It's 10 after. So let's get on to the next one, Jeff.
Okay, we have Bob. I think.
Hi, guys. Just a real quick question. Last week you said to file the FDCPA, and when I went on the site, I found some for credit cards from Florida, but I didn't find anything for Georgia or anything on a foreclosure on my house. So where is that at?
Georgia
FDCPA lawsuits are federal lawsuits. They don't apply to Florida. They don't apply to Georgia. They apply nationwide, all 50 states. And that's all that matters.
Yeah, don't they quote
the issues? Your state, if you're bringing in state action in with the FDCPA, you have to go research that, your Georgia Act. The way we've designed the website, we did it on purpose because everything on that website is going to apply to all 50 states when you go file a lawsuit.
Look under the Georgia
It changes your local rules. Make sense?
Right. Well, when I went in there, I thought I saw just them in the template that it said it gave a lot of Florida cases or issues or laws, but I didn't see anything for Georgia. I didn't.
You were into the probably the foreclosure side of it. That has nothing to do with the FDCPA. You're suing under the FDCPA, and you got to study under the FDCPA section. Then
okay. Under what section is the FDCPA? Is it? It's not under foreclosure or save your home. It's
taking their money.
Taking their money. Okay. All right.
So that's I assume for the FDCPA violations, and there's a bunch of tutorials in there. There's a bunch of templates in there, and those templates just keep growing.
Yeah, I saw three templates, but they all seem to apply to Florida, and since it's a federal case, I thought I'd have to cite Georgia laws or something. So, okay, I'll go back in and look at it again.
Yeah, it's a federal case, so you cite federal law. It's not cases. Yeah, those are all templates, but if you read the templates, it'll say the U.S. Middle District of Florida. That's fine. If you're in the Middle District of Georgia, that's just Middle District of Georgia, but 1692 still applies in all 50 states. It has nothing to do with Florida or Georgia.
All right. Okay, I'll take a look at it. I'll take a look at it again. If I can't find something, I'll let you know. Thank you.
Jump onto the forum and say, hey, give me a hand here, man. I can't find this.
I'll do it. Thank you very much.
Bob. Good night. God bless you, man.
Okay, next we have Alan.
Yeah, I got a question regarding foreclosure. If you had a foreclosure in 2005, do you have any recourse?
Wow. Way back in 2005, no. What was the last activity?
That's when the last activity was.
No, you don't have anything at that point.
No.
Nothing that's viable. I can give you some crap to go out there, but it ain't going to work. It's just going to waste your time and effort. It's just not worth it.
Okay.
Your best bet's to go into your credit report and start hitting under FCRA, because the statute of limitations is from the time you find it. You follow me? So if you go in there, right? If you go in there and you find that servicer in there or whoever foreclosed on you, and you find that they were reporting erroneous information and you just found it now, well, you got 2 years from the day you found it. So you can start a suit on them. Make sense?
Okay.
So there is some monetary ways you can go and get some rewards out of it. As far as getting the house back or any of that, it's never going to happen. Too late. It's been 6 years.
Okay.
Okay.
All right,
you
buddy.
have to go in your credit report and see if there's still something on there regarding that.
Of course. And then you start hammering them from there.
Okay. All right, thanks.
All right, buddy.
Thank you. And up next is Karen. Karen calling in by way of Skype.
Am I unmuted now?
Yes.
Okay. Shoot. Sorry. My question is, my situation is similar to an earlier caller. Loan originated in 2006 with First Magnus. A couple months later, the servicer changed to Countrywide. There was never an assignment, just a notice that the servicer was changing. Countrywide, First Magnus's tits up, Countrywide's tits up, and absorbed by Bank of America. Never made a payment to Bank of America. The last payment was made in 2009 to Countrywide. Bank of America got it after that. I'm not in foreclosure. I haven't gotten a notice of default. My case got complicated because I started administrative processes early on, and one of my administrative processes was the Michael Lawrence thing. So right now the thing is quitclaimed into a land trust, and there are documents filed in the county with substituted trustee and things that may not be okay. I'm not sure about that.
I know one of our got put in jail, and I don't mean to scare you, for 10 years because of those documents.
Yeah, and I need to figure out how to unscrew this situation and settle the matter. And I looked at your site. I've done a QWR, already, and no responses and everything like that, more than a year ago now. And so I'm not really sure what is my next step. I mean, how much do I have to unscrew before I can
unscrew
start
it all
settling
and get it back to where it was prior? Okay.
But I'm not even sure how to do that. That's the problem. I mean, I can file an affidavit.
I can tell you how to do that, because once it goes on the public record, I don't know how to get it redacted.
Yeah.
Officially redacted.
Yeah, I was being instructed to file these things, and I didn't even know. I thought that they were. They made sense to me at the time, but now I don't even know what laws they violated. Frankly.
Well, the trustee can return the property back to the original. That's not a problem. Just stop filing stuff like that.
Yeah.
Well, right. Wait a minute. Stop.
To where it was.
Stop. Someone said the trustee. Which trustee?
Well, you were the trustee, obviously. Because you filed a substitution of trustee, correct?
Yeah. No, no. Here. God.
Karen, this is going to...
Michael Lawrence might be able to help me, but I don't...
Karen?
Yeah.
Stop, please.
Yeah.
This is going to take too long to resolve.
I know that. So is there someone...
Right, so write this down.
Yeah.
Office at.
Office at.
Free, the letter N, clear.net. Send me your contact information.
All right. And you are?
There, Karen. That's Jeff.
That's Jeff. Okay. Yeah, I have your email. I mean, I get emails from you.
I'll see what we do, and I'll call Michael Lawrence myself. So I talked to Mike. So I'll call him. I don't agree with that process. That's why I've never joined forces with him, and especially after my friend just got 10 years for that.
Yeah, stuff. And since I'm not in foreclosure, I figure I've got to start doing something to get this straightened out before things get really heavy.
Yep.
What state are you in?
Washington.
Okay. Oh, I got another friend of mine in Washington. Okay.
Yes.
All right, we'll go from there. Let's get in reverse. And plus, I got some contacts. So there's Jeff in Washington that we could get to help you out personally, one-on-one. So. Yeah,
because court procedure, I've already tried that in federal court a long time ago. I was working on a property tax case, and I screwed the pooch on that. So I need some help on the court procedure.
Pretty simple. So just once again,
I know it's simple, but I miss deadlines or I do things in advance of when they needed to be done, and yeah, I screwed the pooch.
Listen, you got to look at it this way. If your boss tells you got to have this done by Friday, and you don't have it done by Friday, what happens?
You get fired.
You get reprimanded or you get fired. It's no different when you go file a lawsuit in federal court. You have deadlines to meet. If you don't get those deadlines done, you get reprimanded or you get fired. It's that simple.
Well, I'm having trouble evaluating what the deadlines are, and one of the things that happened to me in my cases is that I would file interrogatories, and they said, too soon, can't do that yet, and that kind of thing. So I'd get, and then I'd file.
So all you're really telling us, Karen, is you have not read and followed the rules of civil procedure.
That's because I can't.
Let me tell you something, Karen, and everybody else on this call. Make sure that the members keep an eye on their email in the next 48 hours.
Okay.
I promise you're going to be excited. Just keep an eye on it. We're going to eliminate all this nonsense.
I'm a member.
Okay.
Need help.
So keep an eye on the emails. Okay, guys? So let's just jump to the next caller because I want to get off this phone call.
Thanks so much.
9:30. I've been going since 5:30 this morning, so I want to get cranking here.
Sharon, you're up.
Thank you. Can you hear me okay?
Yes.
I had a home that went into foreclosure and was sold without notification, a whole myriad of things that are wrong, and I won't go into them all due to your time. It was completed mid-2009. Is there anything I can do?
What was completed? The sale, the eviction, everything?
The sale.
Are you still in it, maybe?
Pardon?
Are you still in it?
No. No, it has subsequently been sold to another party, but at the day of the foreclosure sale, which I was not notified of, and we were doing back and forth, I had requested documents from them, validation of the note and stuff, and they had ignored it all. The day of the foreclosure sale, the first sale, I got it stopped because they had not answered my demand for information and validation, and they guaranteed, the trustee out of Seattle guaranteed me the sale would not proceed until I was notified, and about 21 days later, the sale was done while I was out of town, and I was never notified.
Of course. And right then and there, you should have sued the hell out of them. And that's what bugs me about all these other gurus out there that just are giving everybody this wrong information. If you don't validate this note and you try to sell my house, that's another attempt to collect a debt. An immediate federal lawsuit. If everybody would understand the power, including these damned foreclosure attorneys, of that FDCPA, there'd never be a foreclosure. It's such a simple dang lawsuit. Simple, simple, simple. I'm telling you, simplest damn thing on the planet. No securitization issues. I don't want to build something that's not there, mountain out of a molehill. It's the FDCPA lawsuit. You're trying to collect an alleged debt. said, I don't owe you, and you better prove to me and to this court that I owe you that money. That's all. End of story. Simple. No complications whatsoever. And you better cut the mustard, buddy, because the judges in the federal court don't screw around. And if you do the site search or do the search on our site, during the case history, you'll read all those federal cases, and every one of them, the judge says, you didn't own it, have a good day. You didn't prove to the court you owned it, have a good day. They throw trustees out, they fine trustees, they fine attorneys, they fine the banks, they give houses away. I don't know you this debt. I don't know who the hell you are. You're in violation of the FDCPA, till maybe the FCRA. Very simple. Prove to me you have the right to be on my credit report. Prove to me that you filed this assignment or that I got notice. That's a condition precedent. And prove to me that I owed you this money. That's it. Those are the simple 3 questions. And some of them, it's only one question. Prove to me that I owe you this money. That's it. So as she said, screwing the pooch, you're screwing the pooch by not hurrying up and filing a federal lawsuit against them. Now, the only thing I can do for you is go back into your credit report, just like I told the other guy, Bob, I think it was, and see, because it's 2 years a day of discovery, if they reported derogatory information that you just discovered tomorrow because somebody told you to go look, well, you got 2 years to hammer them under the FCRA, and you might get some monetary awards. But as far as getting the house back, I don't see it happening.
Okay, that's all I wanted to ask. Thank you very much.
I'm just truthful with you. You might get a few $1,000, or even a little bit more. But, you know, as far as getting the home back, I just don't see it happening.
Well, I'm not wanting the home back. I would just like to obtain the mortgage money back.
And that, you know, I don't know if you can even do that. You said it was mid-09?
Yes.
Look for the state collection law in Washington. I'm not familiar with the state collection law. The federal is 1 year under the Federal Debt Collection Practices Act. And I guarantee you Washington has almost a mirror act. And it generally the home
was actually in Oregon.
Okay, well then look for the Oregon one.
Okay.
Okay, and look for the statute of limitations on that. And generally the states are 2 years, not 1.
Okay.
And if it's 2 years, then you need to get on it.
Thank you very much. I'm just new to your site, and this is the first call I've listened to, and you guys have some awesome knowledge. I appreciate what you're doing. Thank you.
It's simple knowledge, you know. I appreciate the compliments, but guys, we really try to keep this as easy as possible for everybody, and I feel bad for callers who tell me I just don't get it, I don't understand, but then again, she's forgotten more things than I'll ever know at her age, God bless her, and that's just a fact. She knows her specialties, and I know mine, and you know yours, and we don't expect everybody to get it, but we're trying to keep it as simple as possible for everybody. And that's why we're having consistent phone calls and webinars so everybody can ask questions, because that's the name of the game. We have the form, we have everything. If we can come back and answer you and help you get this going, man, that's our goal. That's the mission completed. We're done, you know, because we have to take our country back. We have to. You guys all go to our web section and go look at the news. Go watch a 60-minute interview. I was telling my father-in-law about it tonight, where here's the guy telling them, so who owns the house we're sitting in? He says, I don't know. Nobody knows who owns this house we're all sitting in. And here's a guy from 60 Minutes interviewing the homeowner, you know. It's a sad, sad state of affairs in this country. I don't want to get on my soapbox, but it really is. It really, really is bad. And if we don't take action and make it understandable, but action in numbers, we're lost. It's a done deal. And I sure as hell don't want to leave my son with that legacy. So anyway, next question. God bless you. You have a good night. And do your homework for the Oregon credit, the Debt Collection Practices Act in Oregon. You got to find something there. I promise you there's something there.
Okay, we got Mike in D.C.
Hi, how are we doing tonight?
Buddy, how are you? How's D.C. treating you?
Oh, man, you don't want to know. Mouth of the dragon, right?
You got it, man. I'm asking you.
Mouth of the dragon. So my first question is, we refinanced our 2004 settlement in 2005, and I know for a fact that there's a MERS rider. So my question is, are we in a position where we could challenge, their right to continue collecting mortgage payments? We are not in foreclosure. We are fully paid up. We're in an optimal position as far as I'm concerned, but what I don't know is whether we have, the basis of a lawsuit.
Of course, you always have a basis of a lawsuit.
That's what I would have guessed. That's what I would have guessed. Sorry.
Yeah, one of our good buddies was paid up, completely paid up with Bank of America on a credit card for $25,000 right here in Volusia County.
Well, I don't know how much time
verified the FDCPA. He sued him in federal court, and he won. He eradicated the $25,000. Done. See you later. Didn't ruin his credit, nothing. Guy has an 800-plus credit score. Took him about a year and 2 months to do it. But he says, man, I would do it just for exercise, just to get out there and do it, to learn this stuff. And
okay, so
everybody's got their goal. You know, he didn't want to even go after him on the foreclosure stuff until he learned the rules of that ball dance in that federal court through something smaller where he has nothing to lose. You know, $25,000 for a credit card, no big deal. With you, yes, you want to challenge your original lender, see if they're even still in business. And once again, these are the decisions that Americans are having to make. And they talked about that on 60 Minutes. At one point, does an American say, listen, I'm done paying on my house. It's upside down. I'm just not going to do it anymore. It's ridiculous. You know.
Why would I challenge the original and not the refi? Well, you know, the current mortgage servicer, I guess is what I'm saying. Why would I do that?
That's right. Whoever the current mortgage is, that's your original lender. I don't care what you did 10 years ago, 15 years ago. Whoever's currently holding your mortgage, that's your original lender. Look on that mortgage.
I see. Okay. Now, so what's the big picture strategy? Sorry, go ahead.
Yeah. Just get in there, start challenging them, send them qualified written requests. You don't care if it's been transferred, not transferred, whatever. That's who you want to deal with.
Okay, so do send a QWR. And just last question, where on your website, I apologize, I've been a member for about 2 weeks. I haven't been able to spend the kind of time I would like to on your site, looking around, poking around. I have watched some videos, but where would you suggest I start in terms of educating myself as to getting the QWR that I need to get in and strategizing, you know, what happens after they do or do not respond to the QWR?
Yeah, saving my home.
Saving my home, okay. Well, but that's true even though I'm not in foreclosure, I mean.
Absolutely, because step one is checking through the public records and FERS, Freddie and Fannie. Who really owns your loan?
Right. Well, I did that actually. I did go to the website that you recommended, and it turned out it was it's a Fannie Mae loan. So. Okay,
so it's Fannie Mae that owns the loan now, right?
It would appear to be. Yeah, I mean it's being serviced by Met Home Loans, but when I looked it up on the it did show up as a MERS. It did have a MERS ID to it, and it referenced Fannie Mae somehow, some way.
Yeah, and when did that ever happen? See, that
I'm
you
sorry?
know of. When did that
I'm sorry.
happen?
When did it happen?
Transfer?
Oh, I actually haven't figured that out yet. I didn't know I should even bother to look for that.
There you go. See, if you don't know, nobody in this world's supposed to know but you. When did this happen?
Well, I mean, as far as I know, it got handed over to Met Home Loans at some point after the 2005 refinance. But whether I don't know. I don't even know what the importance of it belonging to Fannie Mae in the first place is. Why is that even important? Because
they violated your mortgage. Your Section 20 of every mortgage out there says specifically that they're going to give you notice of who they sold the note to and who the servicing rights are.
Okay.
So anytime anything changes, it has to be, number one, if it was done after, obviously, May of 2009, it has to be recorded in public records. Florida has a statute that says you have to have it recorded in public records even before TILA. So it doesn't matter. Your state law and TILA require that. But more importantly, your mortgage, that's a conditions precedent, meaning that everybody on this phone call that's been foreclosed on, everybody, I guarantee you that none of them ever met the conditions precedent of the mortgage covenants that they have to follow prior to initiating foreclosure. You hear it over and over. When they transferred the note to this MetLife, did MetLife send you a letter saying, hey, how you doing? We're MetLife, we've been authorized to collect your money. And whoever did they send you a letter saying, hey, we've authorized MetLife to allow or to collect the money on behalf of the owner, Fannie Mae, because the note was sold to Fannie Mae. You don't have any of that documentation, do you?
I really don't know. I may actually have received something from them. I can't say with certainty yes or no. You know what I mean? I'm not really exactly sure.
If you're not sure, you more likely didn't get it. Now, go to public record and do the search on the county record and see if there's an assignment there of any kind recorded. There's not. Okay. I'm just asking questions because at the end of the day, I don't know who MetLife is, why I'm paying these people or anything. So I'm going to send a qualified request to whoever's on that original mortgage and note.
Right.
Very simple. Right. They don't respond. Yeah. I'm going to town, man. There's an attorney in Tennessee who stopped paying his mortgage. He basically said, listen, I'm done with Wells Fargo. Where's the note? Where's the mortgage? Where's the assignments? You don't show me this stuff, I'm not paying you. And in good faith, Your Honor, I'm going to go ahead and deposit the money into the court registry for 6 payments, 6 months, so they can come up with the note, the mortgage, and the assignment. They never have to this day. Done deal.
Wow.
Man. He showed good faith to the judge. Your Honor, listen, I'm all about paying my mortgage. I don't know who they're paying. There's mortgage fraud all over the news, every other news section on every station across this country, and Wells Fargo is implicated in a lot of that. Hello, I don't know. I'm not going to pay somebody because 10 years from now, when I think that my house is paid, somebody could show up and say, hey, listen, you owe me another $100,000.
Oh, yeah, that's the basis of my concern. I mean, it's really a cloud on title for all practical purposes.
You sound like you're not taking it seriously, why this matters, why all that matters, because when you and your wife are happily sitting here and, I paid off my house, and you're 60 years old hanging out, doing nothing, chilling out by the beach or whatever, and somebody shows up at your house that evening and says, hey, brother, you owe me $100,000. What do you mean I owe you $100,000? Here's the note. Well, it was assigned. I paid Fannie Mae, or I paid MERS, or I paid Bell. Well, I don't give a shit who you paid. You owe me the money because they never paid me what you sent them. You follow?
So when all is said and done, I want to get a quit claim deed then, or what is it? I'm actually.
When it's all said and done, you're going to sue for quiet title. Let the judge say, sorry. Yeah, nobody's going to reverse that. The judge ordered it. It's a done deal. And you're before a judge. The way we do it is you're before a judge with no controversy. There's nothing to argue. You see, I'm not going in there saying you didn't lend me money, you're not the trustee, da-da-da. No. Here, the sheriff tried to serve them. They said they're out of business. Here, the clerk of the record said, listen, there's nothing here that shows or reflects anything to anybody but this original person right here that's recorded on the mortgage in public record. You got 2 of the best witnesses in the world. What's the judge going to argue with?
Great. This conversation is recorded, on the website?
It is.
I'm sorry?
No, not on the website.
Oh, okay. So I couldn't go back and listen to it.
Send me an email, Michael.
I will do, Jeff. Thanks. All right. Thank you both very much.
If you want to trouble yourself a little bit, but not a whole lot, go north of Nashville Cathedral on Wisconsin Avenue, about 6-8 blocks. You'll be standing in front of Fannie Mae.
Haha. Yeah, no, I know where they are. I know exactly where they are. I used to drive by them every day. Yep. All right. Thank you so much. Yeah, right. Exactly. All right. Thanks a lot. Bye-bye.
Okay, we have an unknown caller calling in from area code 600.
Hi.
Hi.
This is Jan. I'm in Wisconsin. Can you hear me okay?
Yes.
Okay, thank you. I started out signing up for the Michael Lawrence group as well, and my case never got taken, so I ended up having to figure everything pretty much out on my own, and I did end up working. Are you able to hear me?
Yeah, we can hear you.
Oh, okay, good. Thank you. My foreclosure documents were served here on me December 13th of 2010, and I filed. I sent out a qualified written request and then an answer and a counterclaim with an attachment. The exhibit of the qualified written request went out, and also I filed a motion to compel joinder, all within the 20 days deadline. And
good job.
Thank you. I did the motion to compel joinder, but I must have done it not quite right because I had a hearing for that on Monday, the 28th of March, and I guess I had written it so that Chase Home Finance was to compel joinder. So the judge has given me another opportunity to submit that under myself, which I will be doing. Excuse me. I did a home modification with Chase, which was approved in March of 2009 after about 1.5 years of unbelievable exercises, and they ended up approving me using my fiance's income, and it was almost twice the amount that I had originally had my mortgage with. So I immediately defaulted in my mortgage, and that's how I ended up being going and having my house foreclosed on. I have in January of 2008, there was a refinance of mortgage done by Heartland Mortgage. That's who I did. It was a mortgage broker, and then on the note was done on that same day. But the endorsement allonge on page 4 of the note, it says "paid to the order of," and then it's just blank.
Right.
Nobody's name is there. And then on February 6th, American Franklin Mortgage actually sent me a notice, a servicing transfer letter, was a goodbye letter saying that they were notifying me that Chase Home Finance is going to be my new servicer. And then, let's see, I also have an assignment of mortgage that was done by MERS. Let's see here. MERS, and it says MERS, a mortgagee of record, assigner for a valuable consideration assigns to Chase Home Finance the mortgage executed by me, an unmarried woman, to mortgage electronic registration systems, acting solely as a nominee for Heartland Mortgage Centers. So that was filed in December of 2008, about 8 months later after it actually refinanced. And Chase Home Finance is not on my mortgage. They're not on my note. And I'm just wondering, I'm in a position right now where I really don't know where to go next. I didn't receive anything back on my qualified written request from anybody. And I didn't know if I was sent something out after that or not.
Yeah, you need to sue under TILA. You're done. Like I said, this isn't hard. Are you an actual member?
No, I'm not. Jeff has been sending me such excellent information, and I just, for some reason, this particular, I've been in a little bit of overwhelm with my personal life too, so I just caught this. I was so happy to get this chance to be on this call tonight. So, no, I'm not a member yet. I've signed up to be, I signed up to get information on that website, on the What Lies in Your Debt, and then there was another website, the other one.
And we prefer you don't mention the name of the site on the call. So.
Oh, sorry.
Yeah. But anyway, at the end of the day, you need to go become a member because you have an easy solution sitting here and you put it to rest. It's very, very simple. The loan modification part is the part I don't get because you said loan mod, then you refinance. So I don't know what came first, the refinance.
Oh, I'm sorry.
Loan mod, then you got out of that somehow.
Yeah, sorry about that. I refinanced in January of 2008, and then I did a loan modification that happened in March of 10.
Okay.
So
and you
2 years later.
Did you sign a new note with these people?
Did I sign a new note?
Yeah. Usually they'll want to get you to sign a new note and mortgage because they want you to recontract, and plus it's more securities they just created with your signature. Yeah, they're con men. Don't worry about it. What I suggest you do is handle what you got at hand first. Obviously, you got to deal with what you got to deal with the judge first. Handle that. Once you got that, then move on to the federal lawsuit with TILA for them not answering the qualified written request and go from there. That's my suggestion. I don't know what you want to do going forward with them, but that's what I suggest you do.
Well, is the fact that MERS did the assignment of mortgage to Chase, is that legitimate?
Absolutely not. MERS cannot assign something they do not have.
Okay.
They didn't lend you money. They don't receive money. They don't do anything with you other than pretend to be somebody. It's basically they're a straw man. That's all they are. And I didn't say that. 25 judges have said that.
Mm-hmm. So will your organization help with what my next steps are? Because I don't have any clue what to do. What's next?
Yeah, but you got to handle what you have at hand now first with your motion. You have to do that first.
What do you mean?
You've got time to hammer them with the federal lawsuit. That's not a big deal. You want to handle what you have in presently that you got to do first. Do that now. As the judge said, you have to revise your motion. Revise it. Make sure you handle that.
Yeah, he wants to revise my motion, and he wants me to mediate with Chase Home Finance within 60 days.
Well, what state are you in again?
He wants me to file the motion to compel joinder, and I have 60 days to mediate with Chase Home Finance.
Correct. What state are you in?
Wisconsin.
Oh, okay. Yeah, I'd do your motion, and I'd do a motion in opposition, which if you remember, you would find it on our website, and it applies anywhere. It doesn't really matter because there's no law to support it. The fact of the matter is it's a motion in opposition to mediation because it's not part of the contract. The judge just can't say, oh, I want you to mediate. It's nowhere in my contract. What are you making contractual obligations that aren't there? They can't prove that I owe them a penny. Why in the hell would I want to mediate with them? Make sense?
Well, it does, and that's the last thing I want to do is mediate with Chase because, of course, their attorney called me right after the conference call on this motion to compel joinder, and they said that Chase definitely wants to mediate with me, and of course they do.
Well, of course now. It's up to you. Do you want to mediate with them? But the reality is nowhere in your mortgage does it require a mediation.
But now it's a court-ordered thing that I do.
Doesn't matter. You do a motion in opposition and you have a hearing on that. So, Your Honor, where in my contract does it say that I have to mediate? And where in my contract does it say that any judge can override my contract? Who the hell are you? You can't just say that. It'd be like you saying, well, you know what, I don't like what you're paying Chase. I want you to pay Chase $100 more a month. How's that? Well, that ain't going to work. You can't change a contract on a whim because you want to.
So I could just do my compel joinder and group those all together.
No, they're two separate motions.
Right.
Two complete separate issues.
Okay.
Now, if you want to mediate because you want to stay in the home and you want to fight them, or you don't want to fight them, you're tired, well, then great. Go for it. If you don't, then you don't. Simple as that.
Well, if I mediate, I do want to stay. I want to stay in my home long enough so that I can get quiet title, and then I want to sell my home.
Right. You can definitely mediate. Mediation's not a big deal anyway. So you can go and do the mediation. You don't come to terms, you move on. You made the judge happy, you made everybody happy, and you keep trucking. So it's not like the end of the world if you mediate. John doesn't care. See, I fight him. John doesn't. He couldn't care less. He says, I'll go to mediation. I don't care. It's irrelevant to me. And he's right, really.
So I can go to mediation. I just don't have to agree with if I don't want, you mean?
Yeah, you're not going to agree with anything.
Right.
So what does it matter? Just go, make the judge happy, everybody happy. You couldn't come to an agreement because you feel you don't owe him anything.
Right.
And while you're there, just hand him a notice of dispute, too, while you're there on the debt. And then walk away.
I should give them a notice of dispute on the debt?
Notice of dispute on your debt. While you're there at the mediation. Here, give it to the attorney before you leave. Here, I got something for you, for your client. And you just leave.
Okay.
Leave it be. See what he says then.
Good.
All right, we got to get to the next question. You went silent on me, so.
Thank you very much.
God bless you. Have a great night.
All right, thanks, you too.
How many we got left, Jeff?
Next, we have two questions and then two return questions.
Oh God.
Yeah. And right now we have Belinda.
Cut it off at that. We're done. If not, we'll be here all night.
Yeah.
I hope I won't be long. I thank you guys for all that you do. This is only the second time that I've been a part of your call, and I just learned about you from Carol Davis last week. And I wanted to find out if, number one, if there is a recording number for the calls.
There is.
Okay. May I get it now?
So would you send me an email, please?
Okay. And who is this?
This is Jeff.
Jeff. Okay, and that's office@freeandclear.net.
You got it.
Okay, good. I am in foreclosure. And it's going to be about 2 weeks before the actual sale. And my house is in a trust, and I needed to find out, number one, if that would save it.
No.
No? Okay. Well, I do have somebody helping me on the back side with a couple of motions, and it did stop it temporarily. because I got the first letter like in January, and it stopped it for a while, but then I got the second letter on March 17th saying that they were going to go ahead with it, or I could reinstate for X number of dollars, which is about $4,000 that I don't have. And so anyway, the actual sale is supposed to take place on the 18th. And
yeah, Jeff, what I suggest you do is send them a notice of dispute. Are you a member or not a member?
I'm not. I just learned about you last week, and I haven't become a member yet. Not yet.
Okay, well, if I encourage you to become a member, go to the site, follow the links that are on the email, send them a notice of dispute disputing that reinstatement amount.
Okay.
Now what you've done is you set them up under the FDCPA. If they take any action during that time, between the time they answer you, or the time you send that letter out and the time they answer you, it's a violation of the FDCPA federal lawsuit immediately. You're done. So you got to learn to set them up with simplicity. No complicated things. Simplicity.
Okay.
How did you come up to this number? I dispute that. I don't think it's $4,000. I think it might be $3,700. You know, what are they going to argue with? They got to answer it. By law, it does not matter. And if they don't answer it, they're done. And if they take a step to foreclose, they're done.
It came. That letter came from the attorney, not the actual mortgage company. And this is really about the fourth company that I've had since I've been in the property for about 12 years, 11, 12 years.
Well, send it to the attorney. It doesn't matter. Send it to the attorney. So you see the company, the mortgage company, and you're done. He knows. He's not going to make any moves. Trust me. And if he thinks he is, then you've got to hammer him with the FDCPA, and then he becomes a defendant in the lawsuit because he also received that notice of dispute.
Oh, okay, then. Notice of dispute of the debt.
Oh, it's right there for our members. It's all right there.
Oh, okay. Well, like I said, I haven't become a member yet because I'm an old lady, and I'm a widow, and I've not worked a lot in my life because during my husband's lifetime, I was a stay-at-home mom, and I do work now, but I don't earn a lot of money, and it's just a difficult situation that I'm in. And a lot of people say, well, hey, do you need debt counseling? Or do you live above your means? That's not the problem. The problem is I don't have enough money to just pay my bills. I mean, I'm not a big spinster or anything like that. And I'm just in a bad place. What about judicial jurisdiction to execute a sale?
No, you're getting too complicated. Once again, that's all complicated stuff.
That's complicated.
The easiest solution of all. Easy.
Is to do the notice of dispute of the debt.
That's right. Right to the attorney, and he's representing the client, so it's going to go to his client. He's got it himself.
Okay.
And from then on, it's just, you got to maintain and follow through. If you don't do that, then you're going to lose it, no doubt about it.
Oh, okay.
All right, we got to get to the next question, Jeff.
Yep. Thank you.
I hope it works out for you.
All right, thank you a lot.
Okay, we got Norbert.
Hi, Jeff. Hi, everybody. This is Karen in Alabama.
Hello, Karen.
Hey, Karen.
Yes. We have been with the home ownership program, but we have been foreclosed, but we're still in the house. My question is, we filed bankruptcy, and so Chapter 7 and the lawyer, I've consulted some lawyers, and they told me that we don't have any standing because of the Chapter 7. Now,
they have what? I'm sorry, repeat that, Karen?
We filed Chapter 7 and we had a discharge.
Yeah.
Okay, the lawyer said that we don't have any more standing in the property, and if we do any...
okay. You see what I mean with these dang attorneys? It's just like you can't win. You just cannot win with these guys.
That's what they're saying. So my question is, what can I do? Can I just sue the... what are the remedies available for me, and can I sue the foreclosing the attorneys that foreclosed on us?
I think you can.
How far back was the foreclosure sale?
December 2010.
Oh. Jesse, I don't know about you, but I think she could probably build a good FDCPA case on that.
I think so too. Absolutely, you can.
So is that going to be on the?
Yeah, that's what our whole site's about. I'm telling you, it's the easiest dang thing out there, and there's a reason for that. There's a reason for that because the FDCPA is so dang strong, and people just don't utilize it.
And the other, just so that you know, when attorneys violate the rules in the FDCPA, judges don't like it when they do that. They consider the attorney to be stupid.
Okay, so the action that we can file is going to be against the attorney on their for
attorneys and the banker and whoever else was there, the bank, the lender, the servicer, murderers, whoever is involved in that case. Absolutely.
Okay.
We don't discriminate. We sue everybody.
Okay, so I have to become a member in order for me to access all the information in the website?
Correct, ma'am.
Templates and everything?
Everything's in there.
Oh, okay.
Including instructions on why you do what and when you do it and where you do it and how you do it.
Where are the instructions?
You have to become a member first.
I know, but which way?
So, if once I become a member, where do I go? Should I just go to? Is there going to
go to the members' homepage, and everything is right there, self-explanatory. All the tutorials, everything, saving your home, judicial, non-judicial, everything is there. Saving their home, taking their money, which is the FDCPA, all that stuff.
Okay, one more.
You got to just peruse.
Okay, one more question. What's the time limitation? Is there a statute of limitation for me?
Yeah, 1 year on the FDCPA.
Okay, just 1 year. Is that the same for? Okay, that's fine.
How much can we do then?
Do I have to have phone calls from them, or it doesn't
matter?
No,
of course not.
No.
That's just more money if you do. But no, you don't have to have.
Just so that you know, there are about 70 different statutes in there they can violate. They usually violate about half of them, but you want to stick with the big ones.
Okay, and it's all there in the website?
Yep.
Yes, ma'am.
Okay. Well, thank you.
All righty, you guys have a great night. God bless you.